Hello, I'm Tom Howard. I've been recognized by super lawyers as an authority in bank law, and I'm here with my new collateral-based website to help defend what really matters, that is, the collateral base. I also use it to flatten legal fees so that community banks don't have to pay excessive costs for their commercial banking litigation. And today we have a very special episode of the collateral base. While the stock market is at an all-time high and interest rates next week will probably be bid up at least on the short end of the yield curve, signaling perhaps a recession in the future. Now, we're going to talk about one of the things that's the most relevant to the recessionary factors, the Donald Trump tariffs. I was talking to a farmer just this week. He was saying that the spot price right now is about $7.50 a bushel for soybeans, and from what he remembers last year, it was about $10 a bushel. That is a huge amount of revenue that is being taken out of the pocket of American farmers as they face rising interest rates. Let's also talk about Donald Trump a little more. What happens in 2 months if the Democrats come to office? What's that going to do to the animal spirits that are propelling the market up to all-time highs? That's not here yet. The harvest is coming in, so let's talk about many things that your financial institution can do right now to tighten up their ag loans before they go bad. First, has everyone signed the loan documents that needs to sign them? There's case law out there. There's the Illini Bank case. Oh, if you want the white paper that formed the basis to this presentation, please get in touch with me. This one particular case, the Illini Bank case, or the In re Snyder, where a farm had both a husband and a wife, but only one of them signed the agricultural security agreement and other loan documents. Therefore, the wife was entitled to half the crop proceeds, as the bank only had a lien on the half that was their collateral. Make sure everybody has signed the loan documents that need to. Second, does the agricultural security agreement adequately describe the scope of the lien? Now, when that farmer says that he is going to give you a lien on everything just so that he can make sure that he can go out in the fields and get his crop or plant his crop, whatever. When they say everything, make sure that you draft that agricultural security agreement broad enough so it literally covers everything, because as the lender, as you know, the contract will be strictly construed against you. A lot of these farmers are quite wealthy, so they might have assets that are outside the bounds of what you believe your blanket security agreement to cover. Most importantly, the consumer good aspect. What happens if they have a wonderful art collection or antique carriages? Other assets that are not title-based, because that would be a different method of perfection. But if your agricultural security agreement is drafted broadly enough, you literally can get a lien on everything. However, do you have a future advance clause? That's a very important one. Came up in the In re Duckworth case. The In re Duckworth case didn't have a future advances clause in its loan documentation. As a result, the bank missed out on a lot of proceeds which should have been their collateral. Third, is the UCC financing statement correct? And is it still timely? Many banks use services to make sure that the UCC is always renewed every 5 years that it comes due. But do you have the right name of the debtor on there? Maybe the debtor typically goes by Buddy and his actual name is William. You know what simple piece of documentation you can put in the loan file that will prevent any type of inconsistencies on the UCC financing statement? The farmer's driver's license. Make a copy of it, use that specific name that is provided for on the state ID. That is sufficient. However, if it's a corporate farmer, you can check the Secretary of State's website and use the corporate name that is provided there. There was a case on this exact stuff, In re Miller, the case of State Bank of Arthur versus Miller. Let's move on to the collateral that suffers the most from slippage. That's right, we're talking about the crop itself. That crop gets converted into proceeds typically at the elevator. Now, make sure that your lien goes from the crop to the proceeds. And there's 3 letters you need to know about that. The FSA, Farm Security Act. You send notice of grain buyers out to all the elevators in the vicinity. These notices need to comply with the FSA, specifically Section 7 USC 1631 Parent E, which requires 5 things. And the case law says strict compliance is required with the FSA's notice of grain buyer to protect the security interest so that the buyer does not take it free from the bank's security interest. The bank will be able to follow the money and stay secured. If you don't have strict compliance, those proceeds might not be secure. This was a very famous case, State Bank of Cherry versus CGB Enterprises. And in that case, CGB pointed out that the bank did not comply with the FSA's 5 points, and so it took the crop free and clear of the bank's security interest. What does your notice to grain buyers need? First, you need to make sure that it's timely. They are every crop year, so every year they go out. Second, you have your bank's name, the name of the secured lender. Third, you have the debtor's name, and of course, both of their names and addresses. Fourth, you need the social security number of the farmer. And again, if it is a corporate farmer, then you can use the FEIN number that the IRS gave that corporation or LLC. And fifth, you need a description of the crops, including both where they're growing and where they're being stored. And by where, I mean county level where. So many of these counties out in the agricultural areas, the farm might be in Bureau and, I don't know, Marshall, let's say, is where the storage bins are. And so be clear when you are filling out your FSA notice of lien to the grain buyers that are out there. And Laser Pro does have forms. Typically those 5 things are on there, but if they aren't, or if you're not sure if they are, give us a call and we will walk through them with you. Moving on, have the proceed checks been made out to both the farmer and the secured lender? So your FSA notices are good. They turned the crop into the cash. The check is cut. Your bank's name is on the check. Make sure it is there with an and. That requires 2 endorsements. The farmer has to endorse, the bank has to endorse. If a farmer, without the endorsement of its secured lender, tenders a check to your bank, be careful. The depository bank may be liable to the secured lender in that case. So if you don't want to answer to the secured lender, check the endorsements of the crop checks. Confirm both endorsements on that crop check before cashing it. What about fraud? We don't talk about it enough. Are you policing your collateral sufficiently? Do you know if the number of cattle the farmer's representing is the correct amount in the herd? Are the grain bins full or are they empty? Especially the grain bins that might be located on the farmer's own real estate. It's on you as a secured lender to police your collateral. And if it hasn't been done, you might have a loan that you think's a risk category 2 or 3, and suddenly 5 years and a very expensive and messy divorce later, that risk category might go up to 6 or 7. By that time, it's usually too late. You need to make sure you are secured before the money's gone, not after. Thanks so much for joining us. Hopefully all your ag loans are performing just as well as your other commercial loans. But if you have any questions, feel free to give me a call. If you give me one shot, believe me, you'll just be wishing you found out about our flat legal fees solutions 6 months ago. I'll talk to you soon. Tom Howard, Collateral Base.